In addition to having powers and duties towards vulnerable children, on the 4 stages of the scheme for supporting children that we've looked at, early help, children in need, looked after children and children leaving care, local authorities have powers and duties towards some children who have been looked after or been in care once they leave care. And these are the care leavers provisions. The idea is that local authorities should continue to provide support or services as needed to those who are leaving or have left the care system, because a reasonable parent, the average parent, wouldn't simply, when their child turns 18 or leaves home, say, that's it, you're never going to need any help from me again. And many young people do still rely on their parents for advice, support, perhaps financial support, maybe even accommodation, well past the point where childhood officially finishes at the age of 18. The care leavers provisions are intended to replicate that position for those who have been in the care system or been looked after, particularly for those who have been looked after in their formative years, by which we mean sort of beyond the age of 14. And that's because those children are likely to have least access to other forms of support, so family or other kind of wider social networks through which they might be able to access help or assistance. They might be more reliant on the local authority. If they've been parented by the local authority in that late stage of their childhood, then they may well need to continue to receive parenting style support from the local authority after they leave care. And the idea is that local authorities have duties and powers towards children in young people leaving care, in some cases up to the age of 21, but the new Children and Social Work Act 2017 extends some of those duties through to the age of 25 years, so up to the 25th birthday of many young people who have been in the care system, if they ask for support, if they need that ongoing support from the local authority. The most important provisions relating to care leavers are contained in sections 24A to 24D of the Children Act 1989, sections 2 and 3 of the Children and Social Work Act 2017, the Care Planning, Placement and Case Review Regulations of 2010, the Care Leavers Regulations of 2010, and the Children Act 1989 Guidance and Regulations Volume 3, which relates to planning transition to adulthood for care leavers. There are 4 categories of care leavers in the legal provisions, and the extent of the duties and powers owed to a care leaver by the local authority will depend upon which category of care leaver a young person falls into. Those categories are eligible children, relevant children, former relevant children, and persons requiring advice and assistance. And we'll break each of those down in turn. The first of those is eligible children. An eligible child is a child who is still looked after, is aged 16 or 17, and has been looked after by the local authority for at least 13 weeks after they became 14 and or between the ages of sort of 14 and any point beyond the age of 16. The importance of this category is that young people who are still looked after need to be prepared to leave care. So they need to be aided to develop the skills, the resources that they will require as adults to function independently in society. And so those who are eligible children are children who the local authority are still looking after, so will owe all those duties towards that we've already discussed when we considered looked after children. But they will also be young people to whom the local authority will owe duties as care leavers. And we'll look at the specific duties shortly. Just to break down what the other categories of care leaver are first. The second of those, after eligible children, are relevant children. And relevant children are aged 16 or 17 years. They're no longer being looked after by the local authority. They stop being looked after the age of 16, but they were looked after for at least the 13 weeks between the ages of 14 and 16. The next category of care leaver are former relevant children, and those are young people who are now 18 or over, and either before they ceased to be looked after, they were a relevant child, i.e. they had been looked after by the local authority, had left care, but were looked after for at least 13 weeks between the ages of 14 and 16. Or they were young people who were looked after by the local authority right up until they turned 18, and they were an eligible child before they turned 18. The last category of care leaver is what we call persons qualifying for advice and assistance. And those are young people between the ages of 16 and 21 years of age who were cared for under a special guardianship order after they'd been looked after. So they'd been looked after and then a special guardianship order had been put in place. Then they would be considered persons qualifying for advice and assistance. Or they were looked after by the local authority at some stage between the ages of 16 and 18 years. They were accommodated or fostered, but they're not anymore. But it may well be that they weren't looked after for long enough to be considered a relevant child or a former relevant child. Those are the four categories, and the rights of young people who fall into any one of those categories depends which category they fall into. But for eligible children, relevant children and former relevant children, which are the main three categories, young people will have a right to an assessment of their needs. And this is important because care leavers' needs might be quite diverse. The maturity of one young person or their situation in terms of their future plans might be very different as between different children, different young people. So the first thing is that they're entitled to a comprehensive assessment of their needs to determine exactly what help they're likely to need to help them transition from childhood to adulthood. They have a right to a personal advisor, and I'll explain a little bit about the role of a personal advisor shortly. They have a right to a plan. So in the same way that children in need following a Section 17 assessment will have a right to a child in need plan, the same way that looked after children will have an entitlement to a care plan, the same way that those who have been assessed as requiring early help should have an early help plan. Care leavers are no different, and they have a plan which sets out what support they've been assessed to require following their assessment. And that plan is called a pathway plan. And it's a really important document. And when we think about our mothers and children, one thing that's interesting about the pathway plan is one area of support that must be considered under it is the support that that young person may require to help them develop and sustain family relationships. So that can include support for our mums to develop and sustain relationships with their babies, with their children. And when we've been working on the MAC project and we've been looking at the support provided to these young women who are now care leavers, we've been quite clear with advocates working with these young women and then with the local authorities that it's important that their pathway plans do properly put in place any help or support that young women would need to develop the skills to allow them to parent effectively, or to sustain contact or ongoing relationships with their children and babies if they have been separated. And this is all support that can be requested under a pathway plan and included under that heading of support to develop and sustain family relationships. The local authority also have duties towards all categories of care leavers to provide advice and assistance. And to those who are eligible children, relevant children or former relevant children, there are also duties to provide appropriate support to meet their assessed needs, and that can include accommodation and maintenance where needed, particularly around accessing education and being appropriately maintained or accommodated while they enter further education. But any assistance or maintenance that might be tailored towards their individual assessed needs should also be provided. The role of a personal advisor, who every care leaver should be allocated, is to assist the young person with their transition from being looked after to becoming a fully independent adult. The personal advisor should be involved in preparation and review of the pathway plan, but shouldn't be the person writing the pathway plan for the young person, because that personal advisor is then responsible for advocating for the young person, including in the assessment and pathway planning and pathway plan review process, and for helping to ensure that the support detailed under the pathway plan, so the bespoke support tailored to meet the individual needs of that care leaver, is actually put in place. The guidance also tells us that a personal advisor is somebody who should be committed to a young person's welfare on an ongoing basis. This, we've found during the MAP project, can be quite problematic in that sometimes personal advisors change frequently, or young people don't know who their personal advisor is. They haven't had a pathway plan review for a long time. Where you're dealing with a young mum whose situation may have changed drastically since she left care and since the pathway plan was originally drafted, in that she may have become pregnant or be entering a stage where she's now a new parent and has to, has a whole different set of challenges to respond to. At that stage, it's really important to find out who the personal advisor is and to ask for a review of the pathway plan as soon as possible, because the support under the pathway plan needs to reflect the needs of the care leaver at that stage. And if she is a young woman under the age of 25 whose life has changed dramatically, who might need some extra help and support to manage her new parenting role, then it's really important to see what support can be put in place, what guidance can be provided to her in her capacity as a care leaver. And the way to start that process is by approaching the personal advisor. The pathway plan itself it should be a detailed document. Unfortunately, we've seen many that are checklists and they're quite formulaic and they're quite generic. This isn't really what the law requires of them. Instead, the law requires that pathway plans are detailed plans which show how a care leaver's transition from care to independence will be managed, and how any needs that the care leaver has that arise from that transition to adulthood, how those will be addressed. The pathway plan, as an absolute minimum, must include details of who the personal advisor is. So theoretically, a care leaver should always be able to go to that document to identify who is the person at the local authority responsible for helping to secure their ongoing welfare. The pathway plan should then, as with other plans that we've seen for children in need, looked after children requiring early help support, it should provide details as to what support will be provided, who's going to provide that support, when and how that support meets the assessed needs of the young person. There are specific areas that need to be covered within a pathway plan, and these include support to a young person to help them find employment, support to a young person to help them develop and sustain family and social relationships, and support to a young person to develop the skills they might require to live independently. We've argued for some of our young women through the MAC project that developing skills to live independently includes parenting skills. So it might be that additional support is required to assist them to develop the practical skills they need to manage their parenting roles. The local authorities should set out clearly within the pathway plan what actions are going to be taken to address needs and who will carry out those actions. So a young person should be left in no doubt following the creation of a pathway plan or the review of a pathway plan exactly what's going to be done, how it's going to be done, and by whom.